Thank you for your patience. We're going to switch to the next panel now. We're going to focus on the Toronto Regional Bail Center. Okay. For those of you who practice in Toronto, I know it's been a bit of a difficult transition. Yes? Oh, sorry. Is that not the right one? Maybe I have to hit a button here. I'm sorry. There we go. Oh, now the title's on it. I know it's been a bit of a difficult transition as we've had both 10 Armory and the Regional Bail Center operating. We're very lucky now to have Jennifer Stanton here, who is going to tell us all about what's happening there, and then a defense perspective from Chris Rudnicki. And for those of you who practice there, you know, this is a great opportunity, I think, to discuss just logistically what's happening at this location and hopefully how we can continue to improve. So why don't I just turn it over to you, Jennifer, to start, and then let me know how you'd like the slides manipulated.
Sure. Is it easier? Do you want me to come up there so I can hear that?
Do you want to do that? That's fine with me. Okay, Jennifer's going to come stand next to the laptop and just do it that way. That's fine. So you can just hit the arrows and it should all work there.
All right, thanks. Good morning, everyone. Thanks so much for having both Chris and I. Right now, part of my role is that I'm leading the Toronto Regional Bail Center. As many of you know, the Toronto Regional Bail Center came into fruition about a year ago. And that was when we amalgamated to 10 Armory, the Toronto Regional Bail Center, dealing with all of the bails across the region of Toronto. So today, Chris and I are going to talk to you a little bit about the structure, a defense perspective, and if we have time, the path forward. So the Regional Bail Center is presently divided in terms of allocation of courtroom per division, and it's a bit of a complicated structure. It was a work in progress. So there was some movement to address the high volume in many of the courts. So you'll see that the specific purpose of some of the courts was to assist those matters that were quite busy in terms of divisions. We do have a federal court as well as an IPC court. And now we do have a dedicated female court that derives from Vanier that appears in person on every single first appearance. Right now, our IPC court occurs in 401. An update is that commencing October the 1st, we are actually not going to have that court any longer. We are going to have IPC court occur at 10 Armory Street, and 401 will be a JP-led court, not a judge court. So that will affect some of the functions of the court. So the TRBC not having an embedded judge will necessitate that those matters be moved to 10 Armory. Same thing with guilty pleas. Presently, our judge-led court deals with any guilty plea that is a time-served guilty plea only. If it is not a time-served guilty plea, the matter needs to be traversed to 10 Armory. Commencing October 1st, all of those matters will be moved to that court. So there are some challenges we anticipate that are going to occur given the amount of time it takes to traverse these matters from one courthouse to another. But we're aware of them and, of course, are going to try to improve systems so it moves more expeditiously. So at some point during the past year, it became apparent that of the 12 courts that we have, it has become that many of them, so approximately 9, are almost functioning as remand courts. So this is an issue because it limits, the volume is essentially limiting the number of show cause hearings that we can actually complete in any given day. So we made an initiative to have 3 of the 12 courts dedicated to running contested show cause hearings only. The way that we've organized it is that I, as the lead, will identify on the basis of information that I have at the time, what matters are in fact ready to go to a contested show cause hearing. And then on the basis of their arrest date and length of time that the matter has been waiting to be heard in the system, that matter will have priority. So I will pre-schedule that for the next day in one of our 3 dedicated assist courts. There can be up to 3 and sometimes 4 matters that are pre-scheduled, and that determination is made on what we anticipate is going to be the length of time any one of those show cause hearings is anticipated to take. On the whole, this has assisted us in reaching more show cause hearings. However, as was pointed out in the previous panel, sometimes, and particularly we see this over the months of June, July, and August, our lists become very significant. So at that point, we are looking for assistance from 10 Armory or other places in order to reach all of the contested show cause hearings in a timely fashion. In terms of other courtroom assignments, we do not hear matters that are designated as special bail hearings at the TRBC. Those are scheduled through our trial coordination at 10 Armory, and they occur on a daily basis. Many of you have seen that sometimes there are particular issues with respect to the quick scheduling of these matters. If you have an issue with a matter that has been designated as a special bail hearing, and it appears as though the time is too long for it to be reached, I would urge you to contact me as the lead at TRBC or the assigned Crown, because we can go to trial coordination and insist on an earlier date. There are things that can be done if the date is not satisfactory. Sometimes it will be several days before a special bail hearing is heard because of the scheduling needs of the various parties involved, and that's fine too. For an individual, as I said, that is requesting IPC court, they will now be remanded directly to 10 Armory, and that court does function 5 days a week. We try our best to identify what matters are going to be prioritized on the triage list. So some of the efforts that we've made, even in the past several months, have been to contact duty counsel or private counsel directly to confirm availability of sureties. I will pre-schedule interpreter services where needed. However, we do come into instances where, although a matter is pre-scheduled for a particular day, things change. So perhaps a surety is ill or counsel has a competing scheduled issue. In those instances where a matter is triaged and scheduled for a 10 a.m. start on a particular day, if the parties aren't ready to proceed, then we will need to move on to the other matter or matters that are scheduled for that particular assist court that day. In terms of the process, you are likely already aware that, of course, the initiating party is the division that liaises with court services and charge processing. So a matter comes into the system, it needs to go through TPS, which is what I mean when I refer to charge processing. That information is pushed through their system to the Crown system. So that occurs and takes some time. Once we in the Crown system receive a matter, a bail package is generated as soon as possible, and that's distributed to the relevant stakeholders. So it might be private counsel or duty counsel, depending on the situation. Of course, CSD additionally receives information, so that goes through the DIR, and that information, essentially what that means is it appears before the court in an electronic fashion. One of the challenges that we've identified is the relationship between CSD, so that's Court Service Division if you're not aware, and one of the many institutions that feed into the Toronto Regional Bail Center. So it's not just the Toronto South Detention Center, but it's Vanier and other courthouses across the province and sometimes across the country. But in particular, as it relates to the Toronto South Detention Center, because of the communication process in place, which is imposed as a result of provincial standards, sometimes you'll see that there are fairly significant delays in having an individual produced, even by way of video, from that institution to the TRBC. So it's something that we do continue to work on because we recognize that sometimes it does consume some significant amount of court time. We have an additional specialized team at MAG. It's called the Intensive Serious Violent Crime Bail Team. Just rolls off the tongue, super easy. So sometimes we short form that to the Alphabet Bail Team or the Really Serious Bail Team, but that's the formal title. So I won't go through the criteria. It's listed on the slide deck, which of course I'm happy to share with anyone. But this team will deal with the cases that meet this criteria. At times, they may accept or not accept a case on the basis of their own resource limitations. But the idea is that this team, because they're specialized and because they have additional time to focus on cases that meet this criteria, they'll be in a position to proceed more expeditiously and with a certain level of expertise. Like special bail hearings, they may go through the process of scheduling. So the same comments that I made before apply. Of course, you know, if you need any assistance making referrals, you can reach out to me or another Crown of the TRBC. TRBC has 3 mental health agencies that are actually on site. So it's important to realize that there are at 2201 Finch, so on site, a number of program providers. So we do have duty counsel on site. We have bail program on site. We have Aboriginal legal services and the mental health services that are indicated here. So CMHC, Fred Victor, and CODA all serve the TRBC. There are other stakeholders. You heard about Sound Times this morning that also provide services for individuals that may, as was pointed out in the previous panel, might have vulnerabilities or difficulty accessing supports in the community. So one of them, as I said, is Sound Times, which is an independent organization affiliated with the Downtown East Justice Center. They do provide supports for individuals with mental health challenges. There are some limitations in terms of the supervision that they can provide, and in particular, they don't offer beds. And there's some other limitations that you should be aware of for your clients as well. Special bail hearings, just in sum, there is a 2-hour expectation. So if a matter is anticipated to be 2 hours or more, we are reaching into the territory of a special bail hearing needing to be imposed. So generally speaking, that might be where you have a situation where there's going to be 2 sureties that will be cross-examined, or the Crown seeks to cross-examine them, or perhaps a more complicated matter that's going to consume some significant time. So I've already made comments with respect to what do you do if it's not reached or scheduled in a timely fashion, where it must be a special bail hearing. But those are the criteria, and the process is that it does require that you engage in a pre-hearing conference where certain details will be discussed prior to being able to schedule the matter with the trial coordinator. Okay, so that's kind of a brief review. And of course, I want to turn it over to Chris, and I'm happy to answer questions after, or we'll have our contact information at the end as well.
Morning, folks. So this is a presentation about process at the Toronto Regional Bail Center. And I lack the perspective of the Crown, the sort of nitty-gritty, crunchy numbers and data perspective that the Crown can offer. But what I'm hoping to offer today is instead sort of the defense perspective, what it looks like as private counsel entering the system. And the number one problem that I see that I encounter in my own practice is delay in getting a bail hearing heard. My experience is that I've not once had a hearing heard within 24 hours, notwithstanding the criminal code and charter requirements of such a practice. And only very rarely have I had a hearing heard within 3 days. That's my own perspective as private defense counsel. I'm not doing, sort of the kinds of cases that duty counsel might do. And I'm also typically only doing like quite serious cases as well. And I also don't run a ton of cases at the trial level because I'm an appeal lawyer. So with all those caveats in mind, I still have some assurance that that experience that I have in systemic and lengthy delays at the TRBC is not isolated, that a lot of people share this experience with frustration at getting bail hearings heard. We've discussed the triage list, and that's Rachel discussed it in the last panel as well, where there's often 20 or 25 or 30 matters that are in priority ahead of you when you show up the morning after your client's arrested. And that's caused by a series of structural factors, some of which we've discussed today, and some of which are beyond the scope of our presentation, and many of which aren't in the hands of defense counsel. There's nothing you can do as a defense lawyer to remedy the structural and systemic delay. But there are some steps that you can take to try and get your case heard, some short-term practices that I'm going to review, and one application we can try to bring, I think, and with success make it law on appeal, and that would hopefully result in some structural change. So the short-term tips, the first one, we discussed this, Jennifer and I, in preparation, is just you gotta be around, which is a real hard thing to do because we're busy defense lawyers. We have a number of other cases on our docket. When a client gets arrested, it's not like we have advance notice. We may be in the middle of a number of other tasks, and it's hard to just drop everything and wait around in bail court. But that is the sort of best way to make sure that if an opportunity arises, a court suddenly becomes available, your matter somehow moves up the triage list, you're there to take advantage of that opportunity. It's frustrating, it's unfair, but it does work. The second thing is schedule a special. And I know this goes to Cassandra's comment earlier, the sort of tension between a client who wants to get out, obviously, as quickly as they can, and you wanting to make sure the matter can actually get heard. But my experience is that I'll often go in and in any serious case, just say, like right off the bat, let's schedule a special, because if we don't, me and my sureties are going to be sitting around all day in court hoping to get heard, and chances are pretty good it's not going to happen. Whereas if we get a special, not only do we get a dedicated court, a dedicated justice who's going to make sure they hear our case, we also have the opportunity to put a bit of time and effort into the materials that might go before the court, and the court hopefully will have some time to read those materials. So we actually aren't just going into the bail hearing sort of sight unseen. And then the third and final thing is, touching off that point, is to prepare a defense bail package. And this won't be news to a lot of you, but I don't permit the Crown to be the only party that's filing a package with the court on a bail hearing. I also want to make sure I'm taking the initiative to do that myself, and doing so in a way that's structured for the court, that's legible to the court, accessible to the court, and so that it's sort of a one-stop shop for everything that they need to make the right decision in our case, which of course is release. So I want to go through just 3 quick examples of bail packages I've done in the last year and a half. These are also the only bail hearings I've done in the last year and a half. So that is an easy resource for me. The first one is a client. This is an Indigenous client who was arrested on a 4th. She had 3 outstanding charges at the time, all violent offenses, and was arrested on a 4th attempt murder charge. All cases where there was alcohol use involved, all cases where there was sort of lateral violence and sort of elements of self-defense. And so in this case, in order to again, help the justice understand why release was the right result, I made sure to start at tab 1 with an outline of the bail plan and the reasons for release that ideally serves as a template for your JP to simply read out in bail court, here's why. I can adopt these reasons as a way to release the client. Of course, include the criminal record, include the synopsis, the surety declaration, and I also in some cases, in many cases, we'll also have the practice of including a substantive affidavit from the surety. So not just the surety declaration that we're required by the statute to fill out, but also a sort of custom affidavit that sets out the surety's understanding of the charges, understanding of the role of the surety, and also their, in detail, bail plan, in this case involving residential treatment. Here's another example where this is actually the same client arrested on a fifth information. Unfortunately, the client was doing well and then had a relapse. I start at tab 1, not just with the plan of release, but also a history of the proceedings. Because as many of you know, there's nothing more painful than sitting in bail court and listening to a Crown read out 5 different police synopses, all of which list like 6 or 7 different charges, and all of which also include a bunch of unnecessary steps about the various investigative steps that the police took to find their guy. And so in this case, I started with sort of a 1-pager that said, here's arrest number 1, here's release number 1, here's arrest number 2, here's release number 2, and so on. Again, with the view to keeping things short by making sure the parties understand from the very moment they step into the room, the lay of the land, the context of the hearing. And then, of course, I also include the most recent release order, so the JP can know precisely what the terms are that the person was out on before they got in, and not just sort of a recitation of the terms from the synopsis, but like, here's what the bail looked like for the JP. In this case, I didn't, so I also included some graduation documents. There was a GLADU report in this case, but you won't always have that kind of material available to you. But I wanted to include a third example because I think this is another important thing to include, especially in serious cases where you're really putting, like, you're sort of giving it your all, there's a real risk of detention. A list of proposed bail conditions. So you're not just sort of there squabbling with the JP and the Crown in court, sort of sorting out what the conditions are going to be. You've already drafted them and identified them for your client, which has 2 benefits. One, of course, puts the Crown on the back foot. They're responding to your proposed conditions instead of you sort of having to, in the ether, prepare conditions out of nowhere. But 2, it also helps on a structural level because you just take that tab out of your materials and you give it to the clerk, excuse me, and then you can reduce the delay that comes from the clerk always having to sort of turn back to the JP and say, and what was the wording of that condition again, your worship? So hopefully that also helps speed things up too. In this case, you can also see, this is a totally separate case, but a very serious one. And in this case, you can see that I also included, in addition to the surety declarations, standalone affidavits from each of the sureties that set out their bail plan. But these solutions put the onus on the defense to remedy systemic delay, and I think that's unfair. I mean, really, we're not the cause of systemic delay. The cause of systemic delay is multifarious, but it really lays at the hands of the state at the end of the day, not private defense counsel, not duty counsel. And no amount of defense diligence is going to solve those deep and structural problems. So I want to close the presentation today with one potential solution that we can actually try and bring about, we can do something about, that will hopefully get at some of those systemic issues, which is a leave requirement for the Crown to cross-examine sureties. So a huge source of delay, anyone who practices in the system will know, is the length of time it takes to hear evidence in bail hearings, the length of time it takes for the surety to testify in chief, the length of time it takes for the Crown to cross-examine them. And at least in my experience, a lot of the cross-examination is a fishing expedition. Crown doesn't have, they may have 1 or 2 sort of discrete points they want to pursue, but in most cases, they're simply asking open-ended questions and seeing if the surety kind of passes the sniff test. And that's a waste of court resources, in my opinion. And in a lot of other contexts, we've curtailed the scope of cross-examination, even for defense lawyers who have a right, or their client has a right to full answer in defense. So I see there's no reason why we couldn't move as defense lawyers to curtail cross-examination of sureties in a bail hearing. I think I've gotten all these things. Yes, and the one other point here is just that most of the areas that the Crown cross-examines on can also be just advanced in submissions. You don't need to cross the surety to make the submission to the court. This surety is not strong enough, doesn't have a strong enough connection to the accused, isn't putting enough money on the line, so on and so forth. There's lots of different ways the Crown can take those sort of positions that they take in cross-examination and just make the submission to the JP instead. And often you'll hear in court, I'm sure this surety is well-intentioned and upstanding and is a good citizen and so on, but the accused is simply ungovernable. And what is the point of having spent 3 hours cross-examining that surety if that's the submission you're ultimately going to make? So my proposal is that bail hearings presumptively proceed without cross-examination unless the Crown can show it's necessary. And here's my proposed test to To cross-examine a surety, Crown must show a reasonable likelihood that cross-examination will elicit evidence relevant to the primary, secondary, or tertiary grounds. Simple test you may have heard before because it comes from the test for leave to cross-examine affiants on search warrants. So my first authority for this proposition is Pearson Leasing. This is a lovely portrait of Justice Sharon, who wrote the decision. And Pearson Leasing is the case that says defense counsels can't simply cross-examine affiants on search warrants at large. They have to bring an application or they can do so, even though they have a right to full answer in defense. And there's two reasons that are offered in Pearson Leasing. One is confidential informants, which obviously has no application or shouldn't have much application in a surety case at a bail stage. But the second, which has direct application, is prolixity in criminal proceedings. The court in Leasing in 2005 was concerned about lengthy evidentiary hearings that were bogging down trials and distracting from the main issues, which is exactly the problem we have at bail. And so here we have this quote from Justice Sharon: "For our justice system to operate, trial judges must have some ability to control the course of proceedings before them. One such mechanism is the power to decline to embark on an evidentiary hearing at the request of one of the parties when that party is unable to show a reasonable likelihood that the hearing can assist in determining the issues before the court." So not an onerous standard, right? To my application, all the Crown would have to do is simply say to the JP, here's issue 1, here's issue 2, here's issue 3, here's what I want to cross-examine on, and here's how it advances the argument. Here's how it goes to one of the grounds for detention, primary, secondary, or tertiary. And my second precedent is the well-known decision from Justice DeLuca and Tunney, which is about bifurcation of bail hearings. So the idea that you can simply run a show cause hearing without having to hear from the sureties, and sort of say to the JP, if you're not satisfied that an own recog is sufficient, then we can move to a surety hearing, but no need to get there until we first sort of move past that first rung of the ladder of bail. And so this is Justice DeLuca talking about how these hearings can proceed with the absence of viva voce evidence from proposed sureties. And he says this should not be viewed as a rare occurrence. So these two cases taken together, I mean, you'd probably want to develop this argument a bit more than I have, but these two cases taken together, I say, can be the foundation for an argument that the Crown ought to be required to first seek leave before they can cross-examine a proposed surety. And what Justice DeLuca is referring to here, because he was like myself, an appellate lawyer before he entered the bench, and he's talking about the process at the Court of Appeal for Ontario. And for those not familiar, at the Court of Appeal, there is never cross-examination on surety affidavits. And these are cases where not only is the person no longer presumed innocent, they have been found guilty beyond a reasonable doubt. And they're guilty often at the Court of Appeal of very serious offenses, attracting very heavy sentences, 6 years, 9 years, etc. And the Crown doesn't ever cross-examine on those affidavits. Not to say they don't seek detention, right? Obviously, in many cases, they are successful in detaining someone and making them serve their sentence on bail pending appeal. But you don't have to have a lengthy evidentiary hearing in order to make the submission that this person is not releasable. That's the point I'm trying to make. And the point and the sort of where that gets us, hopefully, is that we are able to have much more summary hearings that really get to the heart of the issues instead of its distractions, which are most often the case with sureties. There's several advantages, I say, to a leave requirement. Saves court time by dispensing with oral evidence. Like, imagine if all your bail hearings proceeded without oral testimony, like how much faster they would actually go. It requires the Crown to identify discrete areas of cross-examination and empowers the presiding justice to keep them in the lanes, like they wouldn't be able to go outside those proposed areas. It discourages the sort of typical and largely irrelevant areas of cross-examination. Well, you know your son's got a criminal record. After he got convicted last time, you must have sat him down. You must have told him not to do that again. And look, here he is back before the court. What does that tell us about, your capacity to supervise or whatever? That kind of thing, which is typically not very helpful. We wouldn't hear from that kind of thing anymore, hopefully. And it focuses the parties on the actual issues, which is, does the proposed plan address the grounds that are at issue in this case? Is there a flight risk? If so, how does the plan address it? Is there a safety risk? If so, how does the plan address that? And again, the Crown can still argue for detention and would still get detention in cases where it's justified. We just do so without the wasted time of the cross-examination. And I also think it could result in sort of a very focused submissions court. Like, so if the Crown and defense agree not on detention or release, but they agree that the sureties don't need to get crossed, you could sort of pitch it into this judge court that's just geared towards, we're only going to focus on the issues, and a judge can get things moving really quickly and hopefully hear a lot more hearings in a single day. There are some disadvantages to a leave requirement that have to be considered as well. First is that I don't think a surety declaration would be enough on its own. I think if there's just a surety declaration, it's not enough information about the plan. So I think there'd need to be something additional, whether it's an affidavit affirmed by the surety or sort of a written plan that they sign or something like that. But there'd be something further that you'd need to propose for the Crown to have to seek leave. And in the short term, it's going to cause delay because you're going to have to litigate this issue of whether or not the Crown ought to seek leave. And then there's going to be reviews of that decision and it's going to go on appeal. So in the short term, it's not going to be that quick. But assuming it gets adopted, then I think it would, in the long term, hopefully get at some of these systemic issues and cut down bail hearing time. And of course, if the Crown's office doesn't change its culture, it continues to cause delay because you could conceive of a Crown's office that just always seeks leave to cross-examine at large, and that would just cause additional delay. But so it requires, as all justice system issues do, cooperation between the different parties in order to sort of make it work. But I think it's possible. Anyway, that's my thought. Hopefully that's helpful to you.
That was fantastic. Thank you so much. We only have a few minutes left for this panel. We've had some questions coming in online. I'm sorry, we won't be able to get to everything. If in the room, anybody has a question, I'll try to squeeze it in. Can I just ask the two of you this? In terms of the triage list, what if defense counsel hotly disputes their place on the triage list? Like, my client's really vulnerable. It's true he was arrested one day after John Smith, but why does that dictate necessarily the order of what hearings are reached? How is that dealt with? Or is it up to the justice of the peace and bail court?
So absolutely, that does occur, actually, that counsel or duty counsel may raise placement on the triage list. And so generally speaking, they will approach the Crown, who may refer to me as the lead. I'm constantly reevaluating the triage list. So I very much take into consideration if there's particular vulnerabilities. If, for example, there's ALS and deaf language interpreter required, that is going to count towards priority because of what we understand are the limited resources. So the triage list is a bit of a fallacy in the sense that it is so fluid. It changes almost on a minute-by-minute basis. And it takes into consideration all of the myriad of factors that go into what might make something a priority over another matter.
Okay. Maybe we can do one in the room. Does anyone in the room have a question that they would like to ask? Remember, there are books up for grabs. There we go. Oh, that's a ploy. That's Shumka, isn't it? Go ahead.
So Chris, this is more of a question for you, but in preparing substantive materials, and I can tell you as a Crown, I want to see substantive materials from defense. I want to see fulsome surety affidavits. Here's the plan, got the GPS sorted out. If we're going into a hearing, let's really give an erudite tertiary submissions only hearing. Do you find that it's easy to get Crowns to take a look at and go through it and say, yeah, listen, we don't need to worry about primary, secondary, good plan. Let's really cut this down. Or do you find when you have this great package, it's hard to find someone to really get to look at it?
My experience, again, is limited, my experience to those 3 hearings in the last year and a half. So that's really all I've got. But I can tell you that I've never had a Crown, unfortunately, with the time to look at the materials more than maybe a half hour before the hearing. And so unfortunately, I just don't rely on the Crown's goodwill because it's never one Crown. It bounces around. There's always someone who's sitting in one court and then it gets bounced to another court and a different Crown has to look at it. And so the vetter will take a position, and typically I'm not able to pull the vetter off their position. And then sort of I kind of forget about the Crown at that point and focus on my decision maker because and again, it's not a knock on the Crowns. I just think they're overburdened.
Can I just make an observation? I've done some special bail hearings as a judge at 10 Armory. If I get materials like what Chris is proposing here, that's really going to make an impression on me. That's just fabulous work. Okay, so I know it can't be done in every bail hearing, but if you have the time as counsel to put something like that together for your client, believe me, I'm going to read it. I'm sure my colleagues who are justices of the peace are going to read it. That's really an excellent way to get our attention immediately with powerful written advocacy. And in a very recent case you may have heard of that I did in the last few months called Nanabush, the defense took the bold step, maybe arguably, of calling their client at the bail hearing just to talk about their life experiences and what they've been through, right? And if you're nervous about that as defense counsel, remember, can't be cross-examined on the allegations themselves at the bail hearing. But when I heard that man's life story, okay, that made a huge impact on me. Maybe you could do that through an affidavit or something else, but that type of evidence does matter, you know? This isn't some robotic exercise. It's not just about the law and the facts of the alleged offenses and this and that. There's a human being before me, and I want to know more about that. And it can make a really big difference. And I highly encourage you to consider what Chris is proposing here. Again, I know it can't be done in every case. It's very difficult, but excellent, excellent suggestions in broad strokes. No comment on the leave requirement yet. Let's say. Okay, we're gonna take a break. So I think everyone needs to stretch their legs, do something, and we got to get set up for the next panel. But thank you both so much for coming. It was a fabulous presentation. Fabulous.